Stephen, Moe and Kris. Kris, your surname was easy to pronounce, Morrison, Kris Morrison. But yeah, really grateful that you can take the time and the energy to come and talk to our sector. We're recording this, so it will go out across our whole membership. And just a very quick background to Parry Field Lawyers. I mean, the company has about 55 staff, as I understand it, who have speciality in law across employment, property, tax, Schedule 32, the whole gamut. Stephen and Kris aren't here to sort of answer questions specifically on legal advice on everything, but to discuss issues generally that are affecting our whole sector. And they've got a speciality in the company, and both Stephen and Kris have worked very closely, in fact even travelled with NGOs in the field, but work very closely with our members, advise some of our members. Stephen's written a book called, I think, Social Enterprises in New Zealand, a legal handbook, I think is the title. Yeah, so, and has a fantastic podcast, which I can highly recommend, called Seeds, which comes out weekly. And we've just sort of got hold of it now and been enjoying it. So, so yeah, thanks Stephen and Kris, really appreciate it. We'll basically just pile into it because we've got 45 minutes. I know you guys are going to give a bit of a briefing because you've been getting inundated with people asking you questions from the not-for-profit sector. We know what the general issues are, so we'll have a general briefing from you two, and then basically open it to your questions and move it on from there. So welcome.
Yeah, well, thank you, and it's a real pleasure to be here, and we're looking forward to this. Actually, it's going to be good. We appreciate interaction, so feel free to ask questions. What we thought Kris and I would do is just begin with a few comments on some of the typical issues that we're seeing, and then that way we can kind of set the scene, and then we can dive deeper into anything that you want to talk about, basically. We've been seeing a lot in this area. We've acted for charities and not-for-profits and NGOs for many years. And so we've got many clients who are facing the same issues that are probably on your board agendas. So we're really keen to be able to download to you. So what we're going to do is Kris is going to kick us off with some thoughts about, I think we're going to start with leases, Kris.
That's the plan. So, and this will be relevant, I guess, thinking of this from the perspective of either it could be a landlord or a tenant. In most cases, I guess your organisations are likely to be tenants, but in some cases you might have subtenants as well, or own buildings that are partially tenanted to other organisations. And so maybe you've seen a bit of discussion about this issue already in the media. What happens to your lease, and do you still have to pay your rent if there's a lockdown like the current situation and you're not able to use the premises either at all or substantially? And so what you may have seen is that in the current version of the Auckland District Law Society deed of lease, there's a clause 27.5, that does provide for a fair proportion of the rent and outgoings to abate if there's an emergency, and one of the possible forms of emergency is epidemic, and that means that you're unable to access the premises to fully carry out your ordinary business or activities, and that's by reason of could be a variety of circumstances, but one of those is where there's a government order that prevents you from accessing the premises. And so that clause was introduced into the leases in 2012 following the Christchurch earthquakes, because there were issues with the red zone and businesses not being able to access their premises. And so if you have entered into a lease after 2012 using the ADLS form, then that clause is likely to be in there. Even if you've entered into an agreement to lease and have never signed a formal deed of lease, if it's an ADLS agreement to lease from after 2012, then it probably still incorporates the provisions of that version of the deed of lease, and therefore that clause is probably there. And the main point of discussion so far has been, well, what's a fair proportion of the rent that should reduce? And there's not yet any agreement on that, but certainly one possible stance is that if you are 100% unable to use the premises, then arguably 100% of the rent and outgoings should cease to be payable. On the other hand, a counter view has been put forward that you need to ask, well, what are the circumstances of the landlord, what are the circumstances of the tenant, and try and reach agreement on what a fair outcome would be for both landlord and tenant. So that's an ongoing discussion, and certainly happy to ask or answer other questions about that. But a couple of other things to be aware of: not all leases use that form. So any leases earlier than 2012 don't have that provision in there, and it's likely to be harder as a tenant with an earlier lease to argue that you're entitled as a matter of right to a rent reduction, but that doesn't stop you from trying to negotiate a fair outcome nevertheless with the landlord. Also, there are other forms of lease, like for tenancies in malls and those sorts of things. They tend to use either their own special form of lease or one that's been prepared by the property council, and again, those rent abatement provisions for loss of access to the site aren't usually there in those forms of lease as well. But it's always worth having a look at the lease and figuring out exactly what's there. So just conscious of time, I'll move on from that one at this stage, but if there are further questions about that, we can come back to that later. But Stephen, I think you were going to talk now about frustration and force majeure.
Yeah, so the thing with contracts is that you have to come back to what was actually signed. So I think one of the things to take from what Kris has been talking about is actually get the lease out, have a look at the wording. It's probably going to be specific to your situation. So it's really hard to give a blanket, you know, this is the position. You need to actually look at your documents. And so that flows in nicely to the next topic, which is just thinking about contracts that you may have entered into as an organization. And in particular, if you have services that you were providing or any type of obligation, or if you're on the other end, if somebody was providing things to you, then it's worth pulling out the contracts and looking at them, because it's possible in contracts to have something called the force majeure clause, which is French for superior force. So what that's actually getting at is that something has intervened between the original intention of the two parties. So the original intention was I was going to deliver to Kris a shipment of chocolate, but something has intervened that we could never have foreseen. They're sometimes called act of God clauses. So something that's way beyond, you know, quite often these would be sort of earthquakes, you know, hurricane, something that's completely destroyed infrastructure, and therefore you don't have to comply with the contract. In this case, the reason that it's important is that you look at the contract, and almost all of them will be quite different. So it's important just to see what are the grounds of claiming force majeure. And I'm not sure how relevant this will be in the context of some of all the work that you're doing as, you know, NGOs with an overseas focus, but it may be that you do have contracts in place to provide something. So that's why we're mentioning it. But basically the contract usually will have a clause that will talk about this. And the key thing is to look at what are the grounds for claiming force majeure. Sometimes they're very specific. And if they're very specific, then you need to fit within those criteria. So the key thing in our current context would be, is there reference to a government lockdown of some kind? Is there a reference to a disease or epidemic? So those are the obvious examples that would match our current situation. But it's possible that they aren't that specific and they simply refer to an act of God or, you know, circumstances beyond the reasonable control of the parties. So once you've identified well, first of all, is there a cause? Second of all, what does the cause say? And then the third thing is usually the cause will say if there's a force majeure event, then the party that's suffering from it can give notice to the other party and essentially suspend the contract for the period that force majeure goes on. So you're not terminating the contract, it's not getting rid of it, it's simply saying while this thing happens, we can't perform our obligations. So that's why it's quite important in our current context, and particularly if there's some obligation that's on you to perform a contract, checking what your contract actually says. And then the final thing on force majeure is sometimes there will be a clause that says if it goes for more than, 30 days or 15 days or whatever, then sometimes there's a termination right as well. And you can actually terminate the contract as a result of the force majeure. So that's kind of a contractual way of dealing with this. I'd also be encouraging you, this is a well, unfortunately, it's a chance to look at your documentation and all your contracts and just check them and see what they say about termination, and can you actually give termination in any contracts that you might need to finish due to the drastic situation that's happening in terms of income and giving and all the things that we'll be talking about shortly. So those are two really key things. And then the final thing is that there is also a doctrine of frustration. So this is at law. It's possible that contracts can be frustrated, but that's quite specific, and you'd probably need to look at the specific circumstances around the contract and what it was actually providing to work out if that doctrine of frustration would apply. Force majeure, in a way, it's an example of frustration because it's contractually written in that if this happens, then you can suspend. But it's possible for it to, for frustration to apply in other contexts. But I'm not deliberately not going into full detail here. We've actually written an article on the leases point and on this point of force majeure. And in the chat, I put a link to the leases article, and we're happy to share that. It's just freely out there as well. So Kris, can I hand back over to you? And when we get this initial spiel done, then we'll open it up to discussions. So just don't worry. So Kris.
One issue that I was going to talk about was just in relation to insolvency and the obligations of the board of a charity in relation to reckless or insolvent operations. Most of your charities, well, the structures could vary. You might be incorporated societies, you might be charitable trusts. In some cases, you might be limited liability companies as well. For those of you that are companies, then the Companies Act is going to apply, and it has specific duties in relation to reckless trading and insolvent trading. And you may have seen, hopefully, again in the news in the last few days, that there are some planned safe harbor provisions that are going to be introduced into the Companies Act in the near future. A bill's going to be passed that makes some changes to the Companies Act, so that if you are able to certify that your company was solvent as at 31 December 2019, but is likely to face liquidity problems as a result of the COVID-19 pandemic, then potentially there's some relaxation of the standard duties that a director would have in terms of insolvent trading and reckless trading. Now, for those of you who are involved with charitable trusts or incorporated societies, there aren't the same express detailed duties outlined in the legislation that governs those. So the Incorporated Societies Act, at least the 1908 version, and the Charitable Trusts Act 1957, not the same level of detail. But if you do end up in a situation where one of those entities becomes insolvent and a liquidation results, then in both the Incorporated Societies Act and the Charitable Trusts Act, there are provisions that say on a liquidation, the liquidation provisions in the Companies Act apply to govern how that works. And so it is important to be aware of that, just because there are some provisions in the Companies Act that allow a liquidator to make essentially the board personally liable for ongoing trading activity which has caused loss to creditors. And again, not as detailed in some ways as some of those duties in the Companies Act, but if there was a finding that the board of a charitable trust or incorporated society had allowed it to continue to operate in circumstances where creditors incurred a loss as a result of that, there is a potential for personal liability in some circumstances there. So that's all I'm going to say about that one. Again, just keeping that brief. And then, Stephen, I think you were going to say some more about governance in general.
Yeah, and I think just before I do that, just to follow on from that, Kris, this is kind of an unprecedented time. So we don't want you to get too worried in terms of how liability works. The government is going out of its way to make changes and to recognize that it's not normal. So they're introducing rules about insolvent trading as well, and they're introducing all these changes that Kris and I a week ago or 2 weeks ago would have said that will never happen, you know. So just bear in mind the context. The reality is that every organization is being affected by this, and I think in the future people will look back sympathetically at people who are making their best efforts. But it leads on nicely to this point about governance. So I'm not sure how many of you are in the governance position within your organizations, or if you're on the boards, or if you're the CEOs, or if you're the whatevers, but I think this is relevant for everyone. So the first thing is, I think it's really important. I do some training with the IOD, and at the IOD course, they go for a week long talking with directors about their responsibilities. And the key message that I always try to get the directors and the governance bodies to get is ask questions, be rigorous, and document everything so that in a later time, in 2 months, in a year, or whatever, if anybody looks back and asks questions about the process, like what were they doing, what were they thinking about, that there's really clear minutes that the board met on this date and we considered all of these factors and all of these things. We looked at these different options, we reviewed the accounts and the budgets, and then we made decision A, B, and C. And I think sometimes boards and governance bodies do most of that, but they don't document it. They don't record the process. So I guess my first encouragement would be just record things, keep things clear that this is the process that we went through when we were making decisions. And that's particularly relevant as we're probably going to talk at some point about staff and employment and redundancies and all this type of thing, you know, as well as that, you know, budgets and how much money have we got left? How are we using our reserves? And have we applied for the wage subsidy scheme? Have we documented that we can foresee a 30% drop in a given month? You know, just being really clear with your governing body that it's their responsibility to take all this very seriously and to document it. So that if there ever was questions, and with the wage subsidy, for example, they've said throughout the documents, you know, we may come and ask you for more information. We may do investigations at some point. The reality is that there's literally tens of thousands of organizations applying for this. But I think it's better to be prudent and record and document the decisions that are made. And then the other thing is that I think this is a real chance for your organizations to show true leadership. The staff, the people, the volunteers, everyone is looking for guidance and leadership at this time. So this is really a chance for you as the leaders of the organizations, or reporting to the board or the board itself, to really set the tone for the organization. How is the governing body responding? What's the messaging that's coming out? Is it consistent? Is it clear? You know, this all sounds really basic. So I, you know, in some ways I struggle to say it, but I think it's good to have these reminders that this is a chance for us to step up, for our organizations to actually really lead well in turbulent times. So that's the encouragement there. And then the final bit on governance that I'll mention is just, you know, this is obviously a shock to many organizations. And so what does the future look like? How as governing bodies, how as leaders, as CEOs, as whatever the title happens to be, what does this all mean for the future, and how can you start planning now for the changes that you can already foresee are coming in terms of revenue flows and donations and grant funding and all these things. What does it actually mean for your organization? And try as much as possible, apart from the probable pulling your hair out, what does this mean for the future? How can we be as proactive as possible and take this disruption, and hopefully have our organization be nimble enough to adapt and move forward. So that's just some thoughts that I've been having on governance. And I know Kris and I have been reading a lot on that, and we can share some of the links if it's of interest. But it's not purely legal, but in some ways it is really important to get that piece right. So Kris, did you want to mention health and safety and privacy, or do you want me to? Or?
Well, why don't we open it up for some questions at this point?
Yeah, just on the material you were just referring to, it would be really helpful to circulate that, because I do think that is a large part of our challenge is, that leadership question and how calmly we can navigate what is an incredibly turbulent and ever-changing context.
Yeah, well, happy to do that. I can email it, and then you can do whatever you want. I mean, Harvard Business Review, I find lots of their material is really relevant and good, and they've been putting out quite a few little snippets, like even, working from home, here's some top tips and stuff like that I think organizations can really benefit from.
Yeah, and Molly will put together a whole bunch of links that Stephen and Kris have sent us, and we'll put those up on the CID website as well, so everyone's got access to them. Okay, so that's fantastic summary and overarching look at some of the issues. And I know you've got a really good mixture here of CEOs, of senior management, of staff. So why don't we open it up to questions? So either raise your hand in the chat room. There's a button down the bottom to raise your hand, or just sort of turn your mic on and butt in and throw some questions at Stephen and Kris.
Yeah, I'll just say as well, the employment wage subsidy question, we've actually written a whole bunch of articles on that, including the latest article, which I think is now up, which talks about statutory holidays, Easter, and what does that mean for lockdown and employees. So we'll definitely put those in links. Neither Kris or I are specifically employment lawyers. We mainly deal with charities and not-for-profits and NGOs in terms of setting them up and keeping them running. And then we do a lot with companies and investments and impact investing and social enterprise. But we have got a bunch of resources on the website. So I think it's probably going to be efficient to share those with you.
I'm happy to say one thing about the question that Paul has in the chat there, which is that so again, making a distinction between employees and contractors, because there is a distinction there. But for employees, if they were made redundant, then there are the usual processes that employers are required to follow, and those still apply. So that includes consulting with the employees properly, giving them adequate information as to why you're needing to restructure and why their position is therefore potentially redundant, and giving them a genuine opportunity to input into that process. But I wouldn't think that the mere fact that the employer chose not to apply for a wage subsidy automatically meant that there was legal comeback, because that decision, of course, the wage subsidy doesn't come close to covering all the costs and expenses and ongoing expenses that an organisation might face. It certainly helps in terms of wage costs in particular. But if an employer in good conscience formed the view, actually, when you look at our costs altogether, we can't continue to operate, and the wage subsidy by itself is not enough to allow us responsibility to carry on at this time, then potentially that would be a valid decision. it's obviously it's going to depend on the facts, but potentially that's going to be a valid decision.
Chris, so is the overarching message then that employment law as it stands obviously still applies, but then if you were doing a restructure or making someone redundant or whatever, do the same periods of consultation apply?
So, I mean, basically yes, but it is certainly is extraordinary times, isn't it? So normally when there's a redundancy type scenario, you're talking about weeks to carry out a proper consultation process. But I guess at the end of the day, if you decided actually our organisation genuinely doesn't have any money, genuinely doesn't have any ability to pay anyone, and it's because of this pandemic and the circumstances that it has created, if you don't have the money to pay them, you don't have the money to pay your employees, unfortunately, and so that's that may be the reality.
I'll just say on this, having said I'm not an employment lawyer, I did help prepare a checklist for organizations to use to make sure that they've followed the right process when they're applying for the wage subsidy. So I might just, if it's okay, I might share that with you and then you can share it on with the others. But basically it's kind of what I was saying before: ask questions, be informed, and then document your decision. So it basically has a little spreadsheet which looks at 2019 figures, 2020 figures, and looks month by month. And then you just handwrite in, revenue, and then look at how much of a drop there's been, so that you can have an objective point that we did look at this and this was the decision. And then it's got a bunch of notes about what mitigating factors did you take? Like, did you talk with your bank, or did you do other things? So I might just share that with you. It was actually created in the context of a church which wanted to look at this, because you can imagine for churches across the country, they're normally once a week, they're gathering people, and all of a sudden that's just completely changed. So yeah, but
yeah, that would be great. That would be great, Stephen. Yeah. Dane, you've got a question.
Yeah, g'day. Hey, if I've got an employee who now can't work simply because they can't get daycare, and we've exhausted our sick leave / annual leave options, where would I need to look to go from there?
And so what I guess the question partly is affected by what the role is, and I mean, it sounds like if you're requiring them to carry on working out, so it's not work they can do from home, for example, if daycare is a need.
Yeah, well, they can't work from home because there's a 2-year-old running around, and obviously partner is also working from home as well. So there sort of isn't the same availability as there once was.
Yeah, I think it's probably going to be best for us to point you to one of our written resources on that, because I mean, obviously there has been quite a bit written about that in terms of, well, what happens, once can you require them to, well, like I can talk about annual leave, for example. Can you require them to take annual leave at this time if that's accrued? Well, again, ordinarily you can have a mandatory shutdown period, but that would normally apply to all staff, or at least all of an area, I guess. And again, normally there's a 2-week notice period that's required for that one. So that's probably not an option. If they can't work, so they're in a position where they're unable to work and they don't have any leave that's relevant, then I guess it's potentially a position where they are having to look at leave without pay, unless you're in a position where you're able to continue to pay them something, even though they're not presently able to work. But if the problem is that they are unable to work, they're unable to make themselves available for work, it sounds like sort of a situation where it may have to be some form of leave without pay. But I would think, again, we'll make those written resources available so that you can work through that in a little bit more detail.
I don't know if this is relevant, but I was just going to say that one of my team are in exactly that situation. And what they've done basically between them and their partner is they've divided up the work week on a 24-hour clock, and they just divide hours and days. I mean, they've worked it out between themselves of who's working and who's taking childcare, and they're just doing a regular 32-hour week or whatever it is across a different set of hours in a day, so that each can fulfill their work commitments. So just people are being creative about this, but it is a terrible situation to be in.
Yeah, I was just going to say that. Yeah, I would challenge them to be a bit creative about it and sort of job share with their partner, or reintroduce the playpen. That was There was always a good use for the playpen. But also the fact that we're not essential services means that we can't act, because there is actually some funding or some resourcing for childcare for essential service workers, but because we're not yet deemed an essential service, I don't think you can access that. Sorry, Kris, you were going to...
No, I was just going to agree that I think being creative, and probably that's right, just challenge that and ask, well, is there a way that this could work? But not knowing obviously the circumstances of this particular employee.
Yeah, and actually in our team as well, Kris, I'm just thinking of the employment lawyer herself, has 3 young kids, and her husband is working full time. So she's having to learn how that works. What shape does that take? And I know it's difficult. I've got 4 young kids. They're running around right over there. You know, it's a completely different context, right? But yeah, I guess it's adapting.
Yeah, and for the record, that adapting is what's happening right now. But we're realizing that this is going to be a marathon and not a sprint, and that there's going to be a limit to how many sort of shifts over 24 hours and stuff people can do before we actually start going, oh, we need to do something different and need to look at options and whatnot. So you're kind of trying to think ahead.
Guy Redding's got a question.
Jersey. Yeah, this is a question, I guess, relating to the wage subsidy. What happens if, for example, you haven't been able to sign a contract because another party's decided, because of the COVID crisis, not to proceed? So if you've got 1 or more contracts like that and therefore lost that revenue, can you apply for the wage subsidy? I mean, we find it a little bit difficult to apply because our revenue is quite lumpy. So it's not easy to make a comparison year on year, but we are faced with a situation where some contracts are not going ahead that we haven't signed yet.
Yeah, I understand the difficulty as well, because other charities that I'm involved with also have lumpy income streams, and therefore when you look at the specific criteria that are currently outlined, which talk about needing to focus on one particular month and show that your revenue is down in that month, exactly how does that play out? But it's over that 6 months period, I guess, from January through to June. And if you would have expected some of these contracts to be confirmed in that period of time and they've fallen through because of the circumstances, it sounds like you would be able to demonstrate that in a normal year we would have expected, or, you know, and again, it's the difficulty, I suppose, is making comparisons with previous years. But in principle, that would certainly be an example of revenue not coming through at the levels that you're expecting as a direct consequence of COVID. So it certainly seems to fit the criteria in that sense. But I think it's probably also a case of working closely with your accountants to ask the question, as Stephen was saying before, how do we document that in a clear manner that shows the factors that we relied on to reach our decision.
And I think particularly just thinking of the startup context, you know, what if an organization had started in January, so they have no historical records to look back on? And what we've been saying is, well, you had an anticipation of what it was going to be, and that's probably enough, because it would be unfair, I think, to say, well, you know, you didn't exist a couple of months ago. And I'm actually the director of a company which is looking at social housing, and we only started in December. So our track record is like literally 4 months. So, but we can definitely look at the environment and say, well, we expected a lot of this type of revenue, and it's just not there now. So we're in the process of applying for the wage subsidy on that basis.
Guy, some of our members, I think Oxfam is one, Himalayan Trust, I think. A few have applied. Kris, you might know more than me, but I think a few have applied for the wage subsidy, even though they haven't been able to clearly show the 30% cut in revenue. And as long as it's roundabout there, and as long as you can make assumptions that you can test, it seems that they're being pretty lenient about the process and the stuff that you have to provide. But Kris, I know you're on the call from Oxfam, you might want to say something about that. But first of all, just a few people had their hands up. Murray and then Pauline from Christian Law Service. So Murray from CBN.
Thanks guys, this is really, really useful. I just wanted to go back to Paul Brown's question. It just flagged something for me. This is the one about the legal comeback if someone is made redundant. What if someone was, say, on 25 hours and when you chunked up their income, it's actually about the same or even less than the whole subsidy? Is there any way of justifying not applying in that case? Because it's at least cost neutral to do so. I hadn't really thought of that before, but it was an interesting little snag I just thought of now.
I think my answer would still be the same. So you're talking about someone whose the hours of work are enough that they get considered as full-time.
Full-time, yeah. So
they just sort of sneak across the line, but actually the remuneration that's payable to them is pretty close to the subsidy level. And obviously that is what the government has said as well, is that they really do want employers to look seriously at, well, is this enough to enable us to at least keep going for a bit longer before we make a final decision, on the basis that that at least is going to sort of ease the sudden abruptness of potentially losing a job when you weren't expecting to lose that on very short notice. At least you've got a little bit more time to prepare. So that, I guess, that's part of their rationale, because some businesses will still fail after the 12-week period is over. Some entities will still fail potentially after that period. So that's definitely there in terms of their rationale. But even so, I think it really depends and will differ from organisation to organisation as to what your biggest expenses are. And for some organisations, wage costs are by far the biggest expense. But that's definitely not true for every organisation. And if you're an organisation that has other expenses that are a much bigger chunk of your budget than your wage costs, and you don't have the funds to continue to meet those costs, then it might still be the right decision to actually, wind things down, hibernate, or potentially make people redundant and stop our operations straight away, rather than waiting another 12 weeks.
Okay.
Yeah, certainly that's a word that I think we're going to hear more of, hibernate, for some organizations. I was talking with one which basically their income is gone overnight. It's a not-for-profit. They had 11 staff, and we were talking about the fact that basically they couldn't afford to keep 9 of them. So it's quite a big change, obviously, but what they're hoping to do is hibernate and come through the period. And for their particular not-for-profit endeavor, it will come back quickly as soon as people go out and are active again. So they're hoping they can trim everything back to the absolute bare bones, get through, and then in a couple months or whenever it is, come back, and then they'd be able to bring those people back in. But yeah, it's certainly not easy.
I've just seen another wrinkle in the Zoom technique that I look like I'm in a film noir movie now, because the weird lights coming in as the afternoon sun drops, but we're all looking very moody. Pauline.
Yeah, about the wage subsidy, we looked at applying, and then I got from our accountants that in fact if you compared March 2019 with March 2020, we didn't meet the 30% threshold. And so, in fact, we had more income this year than we did in March 2019, and that's because of other factors. But I don't know, you know, if the lockdown is just for the 4 weeks, we'll be okay. But if it goes on longer, it's really hard to guesstimate or predict what will happen with your fundraising. We're due to send out another of our quarterly fundraisers. Was due to be lodged with the post office on the 4th of May. Now, because we're not an essential service, we can't direct mail that, nor can the printer print it. But we will then do it electronically. We have an elderly donor base, many of whom aren't on social media, although a lot of them are quickly getting onto it. So the main way we communicate with them is by physical mail. So, but then you can't estimate what the loss would be in comparison, say, to May 2019. So it is a sort of lumpy, you know, the way we raise money and our income flows and ebbs are slightly different than if you're running a business and you're dependent on the sales that week or that month.
Mm-hmm.
So I don't know if you've got any advice on that, or people have had other experiences.
Well, just as a first comment, and Kris will have a comment too as well, I'm sure, but I completely understand because I see this as well with so many charities which do have this sort of lumpy profile. And just as an example, you know, the end of financial year is actually a weird time for charities because people sometimes do put in some donations and things because they want to be within that tax year. So it's caused some confusion in church organizations because they've said, well, actually, the last week of March was like our best week ever because people had scheduled to donate, you know, for the tax rebates that they would get from donating within that financial year. Yeah, so it is odd. If it helps, there's a charities sort of sector group which is coming together. And one of the things in the letter that we're about to send to the Prime Minister tomorrow ask for some clarity on this for charities and also suggest something proactive, which is being done in Australia, which is that for charities, rather than 30%, it's 15%.
Yeah. And
so I think that's a really sensible, proactive way that government could help charities and recognize that there's differences. So Erin's been helping out with that letter, and we're about to hit send literally tomorrow. I don't know what the outcome will be. We have a number of different things. Akina Foundation has given input, their name is on it. So it's a process that's happening. But at a high level, I completely understand. Then the practical answer to your question is if you actually look at the guidance from the government, it's quite sort of vague and woolly. So they say things, we haven't talked about this yet, but they say things like, what are the active steps to mitigate the impact of COVID-19? But they use words like, you know, drawing from your reserves as appropriate. You know, it's not saying you have to do that, as an example. I think it's about documenting your processes, what you looked at, what I said before, really. But I would tend to say, even though it's lumpy, there's definitely big impacts from this. And the example that you gave, you can't send your mailer out. Surely that's going to have quite a big impact in the next month or 2 months or 3 months. So I would be going ahead and applying. That's sort of my feeling, because the reality is the wage subsidy came out as a great headline, and it is pretty cool. Like, that's wonderful. But the amounts that you're getting is actually not that much. So it's not like it's going to save the organization if you get the wage subsidy. It's just a little bit to help.
Stephen, just to come in on that, because there's a question in the chat room about if you have reserves that could be covering a wage that you're worried about, would you be in trouble if further down the track you were audited and it said, oh, look, you had these reserves, why did you apply for the wage subsidy? Or is that a separate issue and you can apply for the wage subsidy?
I'm just looking up the email because I think this question was asked in advance as well, wasn't it?
Yes, yeah, and then I'll come to you, Kris.
Yeah, maybe while you're looking that up, Stephen, I'll just say a couple of things. One is it's definitely the case that you can apply for the wage subsidy before you can prove that your revenue will be down and meet the criteria. So you don't have to be able to prove it before you apply for the subsidy. But obviously, if you apply for the subsidy and then later on it turns out that your revenue wasn't down at all, you know, and there's an audit process or something like that, then there may in fact be an obligation to pay it back, potentially because you weren't, as it turned out, you weren't eligible for it. But in terms of receiving the funds, my understanding and experience has been that you fill out the application form, and as long as you properly fill it out and send it in, they will pay the funds into your operating account pretty quickly. I absolutely agree with what Stephen's saying, though, that you need to be able to document and show why that was a reasonable course of action for you to take, but it doesn't mean that you have to be able to prove the loss of revenue before you make the application. It just has to, I think you have to be able to prove that you had reasonable grounds for believing that loss of revenue would occur.
Are you in trouble, though, if you have reserves, if they find out in an audit that you had reserves?
Yeah, so I think Stephen's going to answer this question in a bit more detail because we've had a bit more of a detailed look at it, and I think that's what he was pulling out his notes on.
Yeah. Yeah. Well, I think the answer, as most legal answers are, it depends. It depends on the circumstances, but hopefully what we're saying is document, look at what were the options, we considered this and that. I think when it comes to that, it would be, you know, how much would you have to dip into, what were those funds set aside for before? I don't think that you have to have used up all of your savings, you know, before you apply or do that. I actually think it's kind of gets a bit confused here. It's more, is there going to be a 30% drop? That's the first step. And then that's kind of the criteria for, yes, we can probably apply. But what they do want you to do is have taken mitigating actions. So this worksheet that I'll send over, it talks about what those might be. And we actually leave a little space in the worksheet where you can write down, you know, these are the steps we did. For example, I would be writing things down like, we looked at last year's budget, we made up a new budget for the coming year on the basis of the following factors, you know, and we did call our bank and we talked with them about, you know, access to funding and flows, and we reached out to the local business association. We attended a webinar like this. we took as many steps as we could to educate ourselves. And I think if you can point to those things, and if you can honestly, with open hands, if somebody ever came to ask the question, you could say, well, look at everything that we did, then I think it's very unlikely that you're going to get even a slap on the hand, because this is a difficult time. I think you just need to be able to say, here's the steps that we took. And the worst case scenario is likely going to be that, you may even need to look in the mirror in 6 weeks and say, you know what, we've got to pay back the wage subsidy because we didn't actually suffer what we thought we were going to suffer. And I think that's it. So it's kind of a fairness thing. It's unusual, isn't it? But it's a bit about trust and not taking advantage of the system. So,
and just sort of building on that as well. I mean, it's a bit odd, actually. I mean, some of the mitigation steps that you can take would be focused on income, and I suppose the example of, well, normally we would do a post run to our donor base at this time, but that's not an option for us, and so therefore we're trying to do it electronically instead. That is an example of taking a mitigation step in relation to your income streams. But actually, a lot of the mitigation steps that businesses are taking at the moment and organisations, entities are taking are focused on how do we reduce our expenses at this time. And the thing that's a bit weird about that is the way the subsidy is phrased is it's focused on reduction of income. It's not focused on, for example, reduction of profit or surplus or any of those sorts of concepts, or, you know, and so you might significantly reduce your expenses, which is an appropriate way of enabling you to continue operating. But that doesn't mean that your income won't be reduced, you know, by 30% still, or whatever. So I think they've had to implement this very quickly, and wanted to make sure that the news got out that this is an option available, so that businesses had the confidence to keep going for a bit longer. But some of those wrinkles weren't able to be thought through as fully as they needed to be, probably. And so that's, again, I guess comes back to Stephen's comment that, yeah, document everything and show what mitigation steps you took, but there's not going to be an obvious right path to follow in terms of what those mitigation steps are, because this has been introduced quickly and without all of the detail having been worked out.
Yeah, I think the big message that we're getting from both of you and just about all of these issues is document every step you're thinking, the rationale, the options you tried, and so on. Kris from Oxfam has a comment or question.
Yeah, well, it was just just to, for the record, I suppose, just to say where we're at, Josie. So we were umming and ahhing for a little while about whether we went for the subsidy. And that was really based on what we thought our March end was going to look like. And to be fair, I'm still not sure. We're about sort of 0.5% away from the 30% one way or the other, and we're not sure. But we have looked at our predictions for the next couple of months, and therefore we are going to go for the subsidy based on our predictions, which is going to be over the 30%. I think just for just to share some of the conversations we've had over the last couple of weeks as to should we or shouldn't we, and a large amount of it, because we were also very conscious of our lumpy income profile, and we did talk for a while about, well, what happens if we average things out over that 3-month period, and maybe we're not meeting the strict letter of the law, but we're certainly meeting the intent. And I think some of those conversations that we had were very much around, if we get audited down the line, are the government going to be so punitive to say, yes, well, you may have had a 30% drop over 3 months, but in this one particular month, you didn't meet the criteria for the exact same month the year before. And would they be, as I said, that punitive? I don't think that's a good PR exercise for them to go through. So we came to the conclusion that as long as we're meeting the intent of the 30% drop, it's probably going to be okay. And the other conclusion that we came to was, if we've got our predictions wrong and we're at 29% instead of 30%, for example, the worst that happens, I think, as you pointed out, is we'll have to pay it back. So our view was, look, if we know we're going to get nowhere near the 30%, there's no point in applying, because you're just going to have to pay it back, and it's just a whole bunch of wasted administrative time. But if you think you're going to be close, we'll give it a go. And the worst that happens, as we said, in 6 months' time or whenever, is we pay it back, and we've lost nothing. And then it's just a question, I think, from an accounting perspective, is do you have it as a liability on your books for the next few months or not? And again, that, I mean, talk to your accountant, but liabilities are a strong part of that. Is the probability of something happening. So you just look at the probabilities of whether you're going to have to pay it back or not, and then determine whether it's a liability.
Yeah, that's a lot of our members, Kris, when we've got together on the CEO call, a few have done exactly that. They've applied for it even though they haven't quite known if they were at the 30% mark or whatever. And, you know, the other takeaway that I take from this conversation, Stephen and Kris, is, yeah, document everything, but also go back to the intent of the law, or these very rapid changes that we've seen in the law through COVID-19. What's the intent of it? And if you're over that in terms of the principles of it, and you're documenting everything, you should be okay. So we're at the hour. So I wondered, you know, Stephen or Kris, if you want to just quickly sum up. If anyone's got a really searing question or comment they want to make, do so quickly now, and then I'll just ask Stephen and Kris to sort of finally sum up.
I'm just conscious of the chat. I see Erin's put something in there about Schedule 32.
Great. Okay,
so just really briefly, Kris and I have done a lot of Schedule 32 applications. So that's to get tax status. Well, you probably all know this, where you're an organization based in New Zealand, but primarily going offshore. And so, yeah, so the question there, Erin, I'll just look at, are you able to comment on any implications on charity's status to Schedule 32 donee status, particularly as the robustness of finance might currently be compromised? Do you want to just expand on that, Erin? Do you mind? Like
No, I'm not able to, Stephen.
Okay.
Yeah. I'm just aware that, you know, one of the conditions of being eligible for Schedule 32 is to be able to show your financial robustness going forward. I'm not, you know, it'd be interesting to know if you've anticipated any potential implications at all.
Well, in my experience, and Kris can comment too, because we deal with the IRD team that does the Schedule 32 applications a lot. And in my experience, they're incredibly practical and very human in the sense of they actually are, oftentimes they're helping the charity to get over the line, to get the status. You know, they're not just sitting there ticking boxes, they're actually asking proactive questions. So my first reaction would be that I think, given the context of everything that's happening, I doubt that anybody's going to be going through with a strict checklist and saying, well, this didn't quite meet the standard that we expected. That would be my first reaction. Do you want to say anything, Kris?
Yeah, maybe a couple of things. One is because getting added, if you're talking about getting added to Schedule 32, it's because it requires an act of Parliament. There quite often are delays when other issues crop up in terms of, you know, the relevant tax legislation that's going to get passed to add you to the schedule. All things being equal, they'll probably pass 2 or 3 of those acts per year. But I would definitely think that there would be delays in the passing of that sort of legislation potentially.
Well, just on that, Kris, we already know there was going to be delays because there was going to be an election this year.
That's right.
And so when I spoke to them recently, they said because of the election, all these Schedule 32 applications that you've been putting in, they're probably not going to be in this cycle, you know, this financial year cycle anyway. So,
and so I think the whole situation will only make that worse. But in terms of the actual merits of an individual application, if they had concerns that it was a newly formed Schedule 32 charity and it didn't have a track record to prove its you know, economic viability, then yes, that could be a problem. But if it's an established organisation that has been operational for quite some time, can show that it's been able to operate successfully, but is now applying for Schedule 32 status, I don't think it would be a problem for an entity of that kind.
Guys, can I just ask you one last question, or just for your quick comment? And I know we're right at the hour now, but someone's just raised the fact that at the beginning you said you mentioned something about health and safety legislation. Yes. And of course, people working from home, you are still in a workplace.
Yeah.
What are the obligations and responsibilities around that?
Yeah, so that's the first point, and that is the crucial point, that under the 2015 Act, place of work has quite a wide definition. It also includes, and you may be aware of this already, but if you have to use a vehicle as part of your job, then your vehicle's a place of work as well, and there can be, if you're regularly, you know, going out and meeting other people, which I guess is difficult in the lockdown, but potentially other places can be places of work as well. But certainly if you're working from home, your own house is a place of work. And so you do have to think about, well, for my employees, what are their work conditions at the moment? And there could be both physical considerations as well as mental and emotional stress considerations. On the physical side of things, do they have a suitable chair and desk? Do they have suitable monitors? Do we know that everything's set up at the right sort of heights so that they're not going to be experiencing OOS or RSI or those sorts of issues? That's definitely a practical consideration that you still have, and need to make sure that you are meeting your responsibilities as an employer in that sense. And on the mental side of things, what are the resources and options that you make available to your staff to make sure that they're able to manage the additional stress of the situation they find themselves in? and have you adjusted your expectations as to what outcome is realistic from them, given that they're working in less than ideal circumstances at the moment. So that'd be one. And maybe just while we're on those topics of working from home as well, just other one that I would quickly mention, in terms of privacy and confidentiality, you're still going to have the same obligations for keeping data secure in the context of the Privacy Act, and if depending on other countries that you're operational in as well, then potentially stricter regimes in some of those countries. So you do definitely need to be asking the question, what measures do we have in place, and how do we know that information that is being accessed by our employees at home is still being held in a secure and confidential manner?
That's incredibly helpful. I feel like we've had a sort of graduate certificate in a whole range of different fields of law. But yeah, incredibly grateful for that. Speaking for myself, but I know that our members will have found that really useful, and we will send the recording out so that we can kind of go over it. We won't hold you to account because we know it's not official legal advice. But yeah, thank you so much, Stephen and Kris.
Can I just say one?
Yeah,
just
and
one.
Please do.
Just a final thing. It is what it is. What's the opportunity that's presented by our situation for each of our organizations, for us as a law firm as well, for you all operating in what you're doing? Disruption has a way of leading to new innovation. So in your context, in your organization, how can you look with a proactive, positive face on what's going on, and what is it that will be reinvented and what will come? So the podcast that was mentioned, I just interviewed Shamobil Yakub, who's an economist, and we were talking there about regenerative economies and a switch from extractive economies. And maybe this is a time when actually things will be accelerated in a way that we could never have done if we were simply continuing on the path that we had been on. So I'll send a link to that one as well, because it's fascinating. We end up talking about the foundation of the future, potentially being words like love and looking after each other, which I think on this call, all of us probably resonate with, but it's definitely not in the business world. So just want to encourage us to think proactively and broadly, how do we enter this new future together?
Yeah, that's spot on. We're compressing 10 years of change into precisely 3 months, I think, let alone a year. Thanks, everybody. We'll get the recording out to you. We'll get all the links from Parry Field Lawyers, from Stephen and Kris, and thanks, everybody, for making the time. Is this a good time? I mean, you don't need all to answer at once, but let us know on email if this is a good time to do these webinars. We'll be doing one next week on financial advice, fundraising, in the new normal, the disrupted normal, and how we can adapt to that. So thanks again, Stephen and Kris, and catch up with you all soon, and we'll catch up with you guys after the meeting too. Thank you.
Thank you.
Thank you.
Very much.
Bye.
Thank you.
Bye.